For the record, I did not have anything to do with scheduling us in this room. This is just the rest of the core team messing with me. So, as you said, I'm Bankim Tejani from Under Armour. I'm the senior manager for digital product security and also the co-chair here for LastCon. And a keynote is that I am not a lawyer, and so we're going to be talking about legal things. But it's one thing to remember is I am not a lawyer for this, and we'll kind of get into why that's important.
And my name is Rebecca Shore, and I actually am an attorney, but I am not speaking here in a legal capacity, so this is not legal advice. And I'm the senior manager for global privacy at Under Armour. And the other note is that we're not here talking about and focusing on what Under Armour does. This is more broadly to discuss and the interactions between security and privacy and the upcoming regulation that's coming to effect in Europe.
Yep. And the other thing to remember is she's not your lawyer either.
Yes.
So let's keep that in mind. One of the reasons we got this talk together and did it is that we've learned to work together really well over the last year and change that I've been in Under Armour, and Rebecca was already there. And we realized that a lot of what we're doing in building security in and building privacy in overlap. And so working together was very natural. We have a good banter. We train a lot together. But it's important for you to have that. How many of you in general care about privacy, whether it's your own or your customers' data? That's awesome. Thank you for caring. How many of you know your company's privacy officer? A little bit fewer. It's a good
you better raise your hand.
a good next step for you to take from this. How many of you have read a privacy, like 100% of a privacy policy, whether it's on a website or your company's? One time. Yep. And it's important to know, like that's, we almost all care about privacy, but not all of us have read the full documents. And that's not uncommon, and let's face it, not all of them are friendly to reading, to non-lawyers, sorry. But how many of you have read some parts of a privacy policy? Excellent. And how many of you work with the company, or does your company do business in the EU? Great. So all of this is going to be relevant, but it's also going to be a great opportunity for you to get to meet your privacy person and to talk, but also to lay some foundational things in the future that you wouldn't have had the opportunity to do if the European government had not done this great legislation.
And I would also say that if you have yet to meet your privacy person at your organization, after the conference, go meet them. It's worth it to have the conversation. I actually also have a cybersecurity background as well. Not all data privacy officers have that background, but it is good because there is so much interplay between what you all do and what I do. It's important to make sure you guys are regularly communicating with each other. So why are we here today? A little bit, Big was talking about the privacy policies. Again, if you guys have consumers, if you have a public-facing document, you have a privacy policy. And for those of you who have read them, and I apologize in advance for those who have read the arduous ones that are very clearly written by an attorney and forgetting that humans actually have to read these things, they are your public promise. They're the statement that your organization is putting out to the world to say, like, this is what we do with data, this is how we care, and this is what it is. And so there's some really awesome ones. I included the LinkedIn. I don't know if you've seen theirs. They have a video. They do a really good job. But there are some really user-friendly ones. And why it's so important is for your organization, and I would say if you haven't read your own organization's privacy policy, go read it, because it's what you guys are required to meet. It's the standard that you're expected to treat data, how you're protecting it, what you're telling people, and it outlines the limits of what you can do. So it's the who, what, where, when, why, and how of what's going on with personal data. And your company may also have a separate one. You guys are all employees, I'm assuming, of a company. So you might also have a separate one that's specific to how your company is going to treat your data. And as cybersecurity professionals, we're focusing more on the consumer component. The GDPR certainly has the employees in mind as well, because it's generally about individuals' personal data. But it is important for you to understand that you have that obligation just as much to protect the consumer's data as you have to protect your employees' data as well. And so, the security controls, then what you guys do is critical to privacy. And so if I wasn't working regularly with Bankim, I would be concerned. you all should be concerned if the data privacy and the security teams weren't working as closely, because the controls you guys put into place is foundational and fundamental to ensuring the promise that I and the data privacy people in your organization have outlined that we're going to meet. And so this regular communication is really, really fundamental and foundational. And we work hand in hand. I mean,
yeah.
I can't even think of a time when there isn't a major project where I'm not, adding Bankim to the list, or he's not adding me if there's personal data involved. Because, I'm looking at it from a very specific data privacy lens at a very high level, focused on what we've said in that privacy policy. And can we do this? And how can we do this? And where are our limits? And what are our constraints? And specifically, there are kind of 3 things I tell people when you're looking at it from that privacy lens that you often focus on. And that's notice. So how have you told people what's going on? Transparency, what's in that? Are you very, very clear with the relationship between parties? And consent, that opportunity for a user to really make an active choice. And in Europe, that choice is a little bit different than you often see it in the United States or countries that have United States laws like the United States, but that choice aspect is really clear. And my guess is most of what you guys do is not looking at those 3 things. You're looking at the technical and organizational and encryption and things like that in the back end, whereas I really, from a data privacy lens, am focusing on how have we talked to people, what are we telling them, are we going beyond what we've promised?
Yeah. But that stitches over to the back end too, and that's where a partnership really makes sense, where you have the front end communication that says you will treat a user's data a certain way or your employees' data a certain way. It's the implementation, the developers, the security team, that can work and ensure that that's actually happening throughout the life cycle of that data. And if you don't have that, then you don't really have privacy built in. You're telling your customers one thing and you're doing something different, which eventually will catch up to you and cause fines and other damage. And now the stakes will get higher, as we'll talk about. But doing all of those things requires implementing privacy throughout your life cycle in the same ways that we've been talking and transitioning the security community through OWASP and lots of other initiatives to think about the secure software development lifecycle, the secure system lifecycle. And so we have to have security and privacy thought of in the same way. And many of the techniques, we'll mention a few of them later, that we think about for security are also the same techniques we're going to need to use to ensure privacy. So we have that tight coupling. The other factor in that is your third-party risk, right? Your software supply chain. And Egypt and Shannon yesterday and other speakers have talked about this, whether it's open source components that you're using, and data integrations and third-party cloud services that you tie to that support your platform, right? Most of us don't build our platforms anymore 100% on our own. So all of those other integrations that you provide, those are places where your data is going to flow through. And you are responsible for making sure that that data, if it's customer private data that you've enumerated in your policy, that those brokers and those partners treat the data the same way that you have said you will.
So we're going to give kind of a little primer, just a little bit high level about like the background of privacy law. I'm not expecting you guys to walk away and be able to quote from this, but it's really critical to understand why you'll hear data privacy people and potentially some security people talk about the difference between European law and countries that have that European kind of model and the United States. And so the key thing here, and we'll kind of start at the bottom, I'm not going to go into the specifics, I'm not going to bore you guys, but you'll see kind of a different trend here than you'll see when we pop up the United States laws. So here you're starting with 1953, the Article 8 of the European Convention for Human Rights. And that is kind of where you start to see, and you can think of why that might have been one of the places they started to see it. But it's respecting that right for your privacy and your family and your private matters. So that it's a foundational, fundamental human right. And that's a trend and thing that you see across the European laws. And so think about that for a second and how we feel about privacy. I don't feel like in the United States, as someone who's from here, I don't feel like it's a human right. Yeah, it's important and I have concepts of it, but I don't feel the same way about privacy as I do maybe about the First Amendment and things like that. And so for them, that's the level at which data privacy and their personal data feels to them. And so imagine, if you're a little bit more cavalier about it, how that would feel to someone if you were doing the same thing in the First Amendment. And you see some other things. So the current law across the EU is the Data Protection Directive. It's from 1995. Imagine what the internet was like then in the world, and computers and technology, and rightly so, they kind of took a pause and said, it's time for us to reevaluate what our laws are. So, the law that we're talking about today is the next version of that. The General Data Protection Regulation is replacing that Data Protection Directive. So it's an update. And then, the same thing with Article 8 of the Charter of Fundamental Rights in the EU is also focusing on consent and personal data and all of those things that you kind of are being built up across European laws. Now, for the United States, we think about it more of a commercial interest. That's just, I'll give you something, you give me it, and we're kind of uncomfortable with the trade-off, and it's just how we are. We treat it a little bit differently.
And also, we think about Europe 1995 being what was the internet back then, right? Imagine what the internet was in 1974.
Right.
And that's still our standing law in the US about privacy.
Yeah, and that's actually focused on the government and their use of data and retention and things like that. And there's a few other kind of interesting laws here. The Fair Debt Collection Practices Act is a consumer protection component. The Video Privacy Protection Act, for those of you who are familiar with the Supreme Court nomination process, that is actually because of a Supreme Court nominee,
Robert Bork.
who was his video rental practices were released in a newspaper, and that law was a reaction to that.
And that's the trend that you see with the U.S. law, right? If you compare, the European laws have this general principle of protecting a right? Protecting the overall entity of what that is, and then they have implementations that will spread into all the different domains. Our laws tend to be reactive to a specific use case, right? So debt collection came about from debtors' issues, and video privacy came about from Robert Bork's video history literally being published. The Driver's Protection Act came about from someone who was stalked and then killed from the DMV data, and that's why you have that law.
And then HIPAA, how many people have ever read the HIPAA notice? Like from cover to cover when you go to the doctor. Other than you signing your name and you've acknowledged, right. And maybe they've not actually handed you the HIPAA notice, but they say in theory they could. So the interesting thing about HIPAA, and the most common question I get when anyone asks me about this, is they'll say, well, it's health data. And I'm like, well, actually, HIPAA's focused on the entity, not so much as the underlying data. So there's a lot of activities that we see in the mobile sphere, on the web, things like that are just not, they feel because it's health data and it feels like it's talking about my health that it's covered by HIPAA. It's not. There are very limited circumstances that are regulated by law that require, and there have been some updates to address kind of high tech is the update to that, and that's in the more recent past than some of these. And then you see the Children's Online Privacy Protection Act. What's the average age for almost all websites and mobile apps that you guys see? Anyone?
Somebody said something.
I thought you were asking what's the legal age.
What's the average age that you see people set that you shouldn't use it beyond, what is 13? And why is that? Because of COPPA. So COPPA actually came out, and it was a great idea. It's a great concept if we want to protect children. And when it came out, almost everybody's reaction, rather than finding a way to find verified parental consent, was to say, we're just going to make the limit 13. I don't want to collect personal data online directly from a child because I don't want to have to deal with that messier component of having to get verified parental consent. So you've seen this reaction across the internet, across everywhere, because the United States was one of the first countries to enact this sort of law. You just see all websites kind of have a 13 and over, right, because they don't want to deal with these things.
And that's a trade-off, and one of the reasons is, as web developers at that time, they said, well, in order for us to have this parental flow and have parental controls for an account that's for a child, they have to re-architect their entire platform to make that happen end-to-end, so that everything that child account does is governed by these parental controls, right? That's a huge design decision to make, and most companies were like, we don't want to do that. That's not what we want to do, and so they copped out, pun intended, of not doing that. The other thing I'll point out overall is we do think of other laws that are about protecting us, like the Fourth Amendment against unreasonable search and seizure. But most of those laws stem from the old common law standards from England in the Renaissance era, but they're still about protection from the government. And these laws, one of the things that is specific is, so for our Privacy Act, it's mostly about the commercial interest, right? It doesn't solely cover protection from the government. And the government has different rights to your data than companies do.
But that's a, yep.
But I don't see Privacy Shield up there.
So Privacy Shield is, so that's a great question. So Privacy Shield is, we have, this is when the law sounds ridiculous, and I get that it doesn't match how technology works, so bear with me. In order to transfer data legally from Europe to the United States, you have to have a legal mechanism, and there are many options for it. One of them is Privacy Shield. Previously, was Privacy Shield.
Oh, sorry.
No,
was
it was Safe Harbor, and it's,
Yeah.
yeah, you're throwing me off.
Sorry.
Was Safe Harbor. That was, the courts invalidated that last year. And now we have Privacy Shield. And so that's not necessarily part of GDPR, but it's a concept of having you still under GDPR have to have a legal right and mechanism to transfer data to the United States.
Right.
So that's an excellent point. We have a lot of companies that have recently tried to certify with the government to be Privacy Shield certified. There are other, like I said, there are other mechanisms beyond Privacy Shield to have your personal data transferred to the United States. And that aspect is really key to one of the things we're going to talk about later, specific to data mapping.
Yeah, and for those who don't know, Safe Harbor and Privacy Shield are both about really still the standing law in Europe, which is when they went to enforce it and they had legal cases that said, oh, well, how can you send data to other countries that aren't following this directive? And so Safe Harbor came about as a treaty, but not at this level of a law, an agreement between nations to say, okay, well, if you follow these principles, then you can do that. And then the Snowden leaks came out and blew a complete hole in that with a bunch of lawsuits that said, well, you said you were doing this, and now you're not. And so Safe Harbor went kaput. And Privacy Shield, many people, I think, expect that will also be challenged in court and taken down unless there's protections against things like what happened in the Snowden leaks.
And so for that particular case, what makes it interesting is if our country was deemed adequate by the European Union, we wouldn't have to deal with that. But again, so you look at, we focus on a commercial interest, and Europe focuses on it as a human right. So they look at the laws that we have in place, and they have evaluated them to deem that they're just not adequate compared to how they feel about it and the rights and obligations and requirements that European citizens have under the law. They don't look at our law the same way, and weren't helped by Snowden and the other things because they were almost given like, oh, this is the evidence of you guys don't treat it the same way, and so it just kind of snowballed from there.
Sorry, one more question.
Yeah.
The way my company is structured, we have different entities. So we've got U.S. entity, then we've got European entity.
Mm-hmm.
So because we've got separate entities, I guess we have to follow GDPR, and then the U.S. entity has to make sure that Privacy Shield requirements are met.
So it depends on where your data is flowing. So one of the things we'll talk about with GDPR is just generally the concept of making sure you understand where the data is flowing. So if you have two entities and the data is flowing between them, you may have Privacy Shield in place. You also could have something called model contracts, MCCs, that could also be between the organizations that allow you to transfer that data between them. So it all depends on how that is. And I will also say, for GDPR, generally it's not necessarily the entity. Your U.S. entity might also have to follow it because it's receiving data, and your expectations are, where the European data is, you're still meeting the requirements for that. So it's something to kind of be cognizant of.
Really quick question.
Yeah.
The company that I work for, we really work exclusively in the UK. With Brexit coming up, I know that this.
No, it's a great question.
Focused on GDPR, but we really look at the DPA in the UK to govern privacy. Are you going to touch at all on UK-specific privacy law, how that's going to?
So it's a little unclear with what they're going to do. Recent indication is that they are going to adopt the GDPR and requirements under it. Brexit has kind of thrown everything into, what's going on with privacy there. And I think I was reading last week that there was some indication that that's what they're going to be doing, but it's still yet to be determined. We'll have to see where they kind of end up and where Brexit comes, because the Brexit process is 2 years, and GDPR comes out and is effective May 25th, 2018. And so Brexit might not have fully occurred. I'm not an expert or specialty in that, so I would say talk to your legal department. But that's, a really interesting aspect of it is if a country pulls out, how does it relate, and do they then follow this? So we'll have to see. It's going to be really interesting to see what happens with Europe,
Yep.
without the UK. So why do I care about the GDPR? And it's a great, you're talking about the UK, you're talking about organizations. Most of you guys raised your hands for you do work in Europe. It's not just about whether or not you have an organization in Europe. It's do you have users in Europe? Do you plan to someday be beyond the United States? One of the key things that is often said in the privacy community is where Europe goes, the rest of the world follows. So with a lot of these type of laws, you can kind of preemptively see, like if I'm just US based, we're going to start adopting some of those things. There are some aspects of it we're going to start to pull in. We're already seeing things like right to be forgotten. At some state level, they're starting to talk about it. You're starting to see concepts pulled from Europe getting disseminated more broadly across the world. And in the United States, the similarity for privacy is California. Where California goes, they kind of lead the pack. The rest of the states kind of tend to follow. Europe is the same way. So it's a good opportunity. So even if you don't necessarily have an organization in Europe currently, to understand where the rest of the world is going to go. Some other aspects of it is if you are in the GDPR, your whole risk picture for your organization, that kind of concept of when you're talking to your senior executives and they're like, why do I care? I really hate when we talk about compliance as the reason why you should care, because I feel like consumer trust and our promise is really the leading factor. But there's also this other aspect when you're looking at that risk picture. And for those of you who were in the last session that was in this room, we were talking about being risk managers and how that's really, for cybersecurity, the same thing for data privacy, really critical to what we do. And the risk picture has changed. And so this is actually kind of a startling figure, and I think it's going to be the rare one-off, but it's really helpful to have that understanding of what's the risk. So the max fine for here, for some components of it, like if you have a problem with not fulfilling your access control, your access requirements if someone requests access to their personal data, is 20 million euros, or 4% of your total revenue from the prior year. That's not like the organization, that's not the entity that is in Europe, that is in total. It's a pretty significant fine. If you don't get verified parental consent, because they will have their own version of COPPA, the age is different, it's 16, although countries like England have said that they are going to have it be 13 like the United States. If you fail to adequately do that, the max fine is 2%. That's a pretty, like when you look at the risk picture and what's going on, that's a change. We haven't had fines like that. Even the fines in the United States don't necessarily reach that level where it's that high of a percentage. So when you're painting the risk picture, and again, like I don't like to lead when I talk about this ever with the compliance component and fines, because I feel like that's, the secondary thing is this is a consumer trust component from the cybersecurity aspect and the privacy component. But it's a good part to have and understand. And often, and you'll see this in other countries, the first time there's some sort of fine, they tend to be larger because they're setting the tone for the rest of the things. You see this in Canada with Castle. There was 4 complaints. It was close to $1 million fine against one company. So you see that the first things out of this tend to be bigger, and you don't want to be that company that is handling that larger fine because you're the first person taken to task for it. So what is personal data? So how many of you at your company refer to what we're talking about as personal data versus personal information? So, okay, most people probably in the United States are hearing it called personally identifiable information or personal information.
PII or PI.
Yeah,
or
all
those
of those
things.
things, yeah. Personal data is actually the European term for it. So you'll find companies that are global or thinking with that global lens will take the transition in order to view it as a more global concept. And now here you see things like information relating to an identified or identifiable natural person. Natural person's a legal term, kind of just know that's an individual, right? And you see this can be directly or indirectly. And it's the indirectly that really becomes the interesting component of it. There was a recent decision about dynamic IP, and your dynamic IP address is personal data. That's what the courts found in Europe.
Yeah.
So things like that, where it's a broadening definition of, we have a clear set of things that are always personal data. I know your name is personal data. It directly identifies you. Your birth date, if it's not connected to you, is a date on a calendar. I don't care about a date on a calendar. I connected it to you. It is now personal data. And so you think about what those links are and how you're able to identify someone and that broader set. And it's complex. It's not always clear cut. And I think the frustration, because if I've identified it as personal data, you pass it off to the security team and you're like, protect it. do what you need to do with it. I've said it's personal data. It's not always as easy because you're saying you're looking at this thing that on its own, I just don't care about, but you've collected enough data elements that I can identify you as an individual, and now that set is personal data, and you have an obligation to protect it like that.
Yeah, there's a bunch of other elements there under the sensitive. But one I wanted to call out that we've come across and that still comes up in conversation is email. Right? So email address, not just in the EU, but also now in the US, is treated as an identifier and personally identifiable information. But derivatives of an email address are equally still personal data. And so when you hear about some, a group or something saying, well, hash the email address and that will take care of the anonymity and we can, somebody won't be able to figure out the email address. Doesn't matter. Because it's derived from the email address, that hash value is still considered personal data.
It's an identifier. That's really the key. It's something that identifies you and collects you and tags you to yourself. So it's those sort of things that you really have to kind of pay attention to from the privacy aspect. And it's why I'm saying the lens from privacy is different than security, because you're looking at hashing in a very different way than I'm saying, well, it's still personal data. You still have to care about it in that context where you're like, but it's hashed. I've done my part. And so that's why working hand in hand with data security is so critical.
And think about a basic thing like a log file, right? Many websites use email address as a username. And when you have entries in your log file that says this user logged in, you log the username, which is the email address. That has now made your log file personal data under some of these new statutes. And so you have to really think about that design and architecture that you have for those basic elements throughout your application.
And there is sensitivity ratings for all of these things, which is why, and now this isn't necessarily the term used throughout it, but it's easier for us to understand. So I'm calling it sensitive personal data. I think it's referred to throughout the GDPR as a special category of data, but this is just a more common term when we're talking about those risk ratings. So you have personal data, and then you have this higher level of data that has an expectation for the security measures and the controls that you all put in place to be at a higher level because it relates to any of these things. And they've added a few data elements with the expansion of the GDPR, and honestly, the expansion of what technology can do from what existed in '95. So you think anything that identifies racial or ethnic origin, political opinions, religious or philosophical beliefs. When you look at this list, you take for a moment and think, why would I care if an organization is collecting these things? Well, you're looking at it from a European context, and in the past, lists like this perhaps were used to influence in ways that we don't want people to influence. And so gathering information like this should be protected at that higher level because we don't want your genetic data, your health information, or certain things to be used against you if it's exposed in certain ways, so you have an obligation to protect it and care for it and at this higher level meet the requirements under the GDPR.
Yeah. So,
Quick question.
Yeah.
Those elements you just kind of listed, if any of those kind of stand by themselves, stand alone, without any of the other factors, are those still kind of considered those highly sensitive or somewhat sensitive elements?
So
or are they only
if you're saying
associated with other elements?
So you're saying if I just had a list of race,
Right.
but I didn't have another identifier. So this is why working with your privacy person is so critical. So if I just had a list of race and broken down at a company, and I said 80% of the people at my company are this race, that's aggregate analytical data. It's anonymous. So you're at the point where aggregate data, anonymous data, isn't covered. It's not personal data. It's not covered under the GDPR. It's not to say there aren't other laws that are required, but you're outside of the scope of data privacy. So it's that conversation. And I would say for Europe, hitting anonymous is a really high threshold. And you have to be really careful. And you really have to kind of understand the likelihood. In the US, it's a little different. But you'll hear people say all the time, and I'm not sure I 100% agree that all it takes is 4 data elements to identify an individual, because I feel like I could pick 4 random data elements and you wouldn't be able to. But they're right. There are studies. I think there was that MIT study.
yeah, it's a bit more clickbait. That
Yeah, but there are studies that have shown that with 4 data elements, you can. I think it's the right 4 data elements. But it is one of those things that on their own, if it's just a list, if it's a compilation, it's not. But if you have, the height of everyone in your company, the age of everyone in your company, the zip code, and their health status, that's probably personal data. Especially if it's your zip to, zip plus 4, right? Zip
Yeah.
plus 4, it's almost exactly. Or if you have all that and lat long, like my precise location is personal data. I'm standing here. This is me. You can identify me by the fact that you know where I'm standing, if there's things
Right.
connected to that. So, it seems subjective, and I will say I apologize on behalf of all privacy people, because that is very frustrating. You guys want
Yeah.
clear, bright line rules, but sometimes it is an analysis of how the data comes together and the likelihood of being able to identify. There are situations where you can pull data back enough. HIPAA has it. They have a list of data elements that if you only have these, it's considered anonymous or de-identified, and you don't have to worry, because together they've done the statistical analysis and you're fine. But it is something to be very aware of, that there are places where you can say there are components, but put enough of it together, the few other things, you have personal data and sensitive personal data. And there are some things here, just to kind of keep your mind about it. When I say health data, I'm not talking about the HIPAA context here, and Europe and the evaluation of what is health data is evolving. And just like I said, with dynamic IP address becoming listed by the courts as personal data. There are obviously exceptions and when that is and things like that, but with health data, that's a concept that they're exploring further to kind of evaluate, where wellness programs, when is something wellness considered health, and how and when. And so these concepts and terms are expanding, and it's I have a colleague that I work with who always says, like, if I'm not keeping up on the privacy news every single day, I feel like I'm not doing my job, because it's changing that quickly, and there's news coming out all the time. Europe's not a country. There's tons of opportunity for evaluations and opinions to come in, and thoughts on these things you have to just be aware of, and again, that's why you work with your privacy person. That's
Yeah. So the next element, and this is really key, and I think to me, being exposed to this and learning about GDPR over the last year, I find this is the single largest opportunity for security folks I think I've seen in my career in InfoSec. The fact that GDPR has been passed and ratified and it's going into effect in 2018 gives us 16 to 18 months to do something that we've never had a chance to do and never had a legal foundation supporting us to do, which is the GDPR requires security and privacy by design. It requires you to do that by design for your application or services. And I put this up there. I'm not going to read it. This is an exact quote from the law. Right? And it tells us, and the things that it points out is when developing, designing, selecting our applications, we have to include security and privacy as part of that conversation. Think about that. And you can lay that down to your part of the business or your business sponsors and say, this is a requirement. Right? You have to engage us before you buy a service, before you use data, before you build something that's going to use customer data. And the law will support you.
I guess I'm used to reading RFCs, but does should mean must, or does it mean should?
So
both those say should, and if I put this in someone who's used to reading RFCs, they're like, cool, I'll think about it.
It's a great point. And one of the challenges is the EU, because of the way they operate and regulate laws, they set this high-level principle first, and then they have people that go figure out how they're going to do it and enforce it. And so that part is yet to be done, but what we can look at is what they've done in the past. And almost always what they do is look at industry best practices. Right? What are the industry best practices, and this is what we're going to measure people against doing. And fortunately, we happen to have some of those. And so these are two different maturity models. BSIM, the one on top, and OpenSAM, which is NOAA's project, is the one on the bottom. And they both are 100% focused on building security in. Right? These are the things that you have to do, the steps that you have to engage in throughout your SDLC, the type of governance you have to have, the type of education and training and policies. So they both talk about those. And there's a pretty reasonable likelihood that the regulators, when they go to implement that requirement of security and privacy by design, are going to say, well, we have these models for security. We don't really have them for privacy, right? They're not there in the same way, but they fit in very, very, collaboratively with these security places. If you're going to think about privacy for building a new app for your users, you need to do that at the requirement stage. You need to have the privacy discussions during architecture and have test cases that support that, and have design patterns and infrastructure and code that all support that. And so with that, to me, GDPR provides a huge opportunity for us to change the conversation from reactive and from defending ourselves to actually building security and in a way that I don't think the law has supported us before.
And I will say from the United States standpoint, you're all in the United States, and I assume your organizations all work in the United States. You're seeing the FTC and other organizations across the United States, our regulators here, also adopt these concepts of engaging early and having it throughout the life cycle and making sure people understand as that they're developing. It shouldn't only be your security person who's ever talked about the concepts of privacy and security. It should be a more thoroughly discussed thing. You're seeing this in the United States, you're seeing this in Canada, you're seeing this in Europe. So it's one of those great examples of you look where GDPR is going, you look where Europe is going, the rest of the world is following. And so it gives you that, that push if you guys are having that struggle for really integrating security. And I think we all have that struggle of saying, like, I'm not a hurdle, I want to be an enabler, and I want to help you do it. And how do you do it? You get me up front. You find a way to make sure that you're talking to me up front so that I don't stop you because you didn't think about security till the absolute last moment. And you didn't think about consent from a privacy standpoint until you're about to launch. You're like, whoa, you can't do that without asking permission. I don't, as a privacy professional or a security professional, ever want to be in that position where you're about to go to production and you have to say no. And engaging privacy by design and security by design ensures that you're having that conversation first and you're not slowing the business down, you're just naturally moving into the life cycle.
Yeah.
So how many of you guys have ever been involved in a privacy impact assessment, a PIA? Okay, so there's one or two. The GDPR has added a concept similar to that. It's a data protection impact assessment, it's a DPIA. I've changed the word a little bit to make it more fun. When I have to spell out the acronym, it means I have to look at it. Sometimes I forget it's a new word. But you have to do this for high-risk processing activities. And so for those of you who have not done a privacy impact assessment, what it does is it walks through what data are we collecting? How are we doing it? How are we securing it? What are the risks that are out there? How can I mitigate it? For the GDPR, they've outlined when you have to do this. Your company may just generally adopt this when you're doing personal data. That's a very common practice. The government, that's generally the practice in the government as well. But if you do have any of that sensitive data, those special categories of data, is an expectation that you're going to conduct one of these data protection impact assessments. And it will include components of security because, again, without security, I don't know how privacy does their job because you guys are foundational and fundamental to it. And so there are components where you're going to say, how do I make this data less high risk? Well, you do that during the conversation to say, okay, you're going to do it. Maybe I encrypt at this level. Maybe I work in the access controls here. And you've taken all these steps. And so this is a requirement that if your company's not doing it in Europe, you will be doing something related to this. I don't know at what level, I don't know how, but it is a requirement for those higher risk activities.
Yeah, it's important to think about that and start to plan. This actually is a good way to introduce yourself to your privacy officer. Say, have we done these, and how can I work with you to do these in the future?
Exactly.
The next requirement is about data mapping. So how many of you know all the data that you collect in your company and everywhere that it goes?
And every third party.
And every third party that gets access to it or pieces of it.
Well, that's,
yeah.
And so what we're seeing, I think, in the industry is that that's very common that there's only a handful of people. And GDPR and under the GDPR, is this expectation that you understand your data flows and the data map. And for the part that I'll talk about before I pass it to Bankim that's unique from the data privacy context is understanding what data elements. So you might know where your data flows, but do you know, and those companies who do are probably at that point where they do, where each components are. If I have concepts of driver's license and social security is here because I have employees, and then over here I have health data, do I understand where those buckets of information are flowing throughout my system and every third party it goes to? And in addition, because we talked about Privacy Shield and we talked about Europe, data coming from Europe, do I know what countries it's going to? And that's the distinction where like that privacy lens, again, is different than the security lens. It's not just about the fact that the data is moving and where is it going and what system is it in. It's the countries. I have to understand what country it's going to make sure we have the right component parts in place. And I also have to understand where those data elements are going so that when we get to, I think, the next slide on deletion and access, I'm able to meet those obligations because I know your social security number started here, went all of these places, and to all of these third parties. So that if I have anything going on there, I can know what to touch and who to talk to.
Yeah. And I think from a security perspective, this is the same information that we want to know. Right? We want to know where we collect data from users. And we may not want to know it for a privacy purpose. We want to know where we need to put in place input validation, right, to prevent against things like cross-site scripting and other sorts of injection attacks. We want to know how it's going into the backend and where it's being stored so that we can put in place encryption at rest, right, or other mitigation techniques that we need in our infrastructure. But from a technical perspective, the regulations around this with data maps and also with the movement of data across countries, they get a little fuzzy sometimes. So imagine you have your data, it's in Europe, you've structured your company so that it's only in Europe. But you have a data mining team or a data science team that's based here in the US and that wants to do some analysis for you. When they run queries and they pull down results, right, it's just data on a wire, but it's actually crossing jurisdictions. And so that's where it gets a little more complicated, right? Now, you still want your team here. Maybe you just have the expertise in the US. But that means they probably have to do all of their activity, all their analysis, strictly within the country where the data is. And if you're not doing that, then you are violating the law. And we don't want to do that. I mean, certainly, if you speed and you don't get caught, is that really a crime? Right? I mean, we don't want to do that with our customers' data, but there are businesses that do, right? There are businesses that will skirt those rules until they get caught. And that's a reason why the penalties have gone up, and the regulators are looking more and more at this. And they have, both government-sponsored and independent organizations looking at privacy of all sorts of apps because they realize this is true.
And the reason, again, why the fines went up is they want to be able to give you guys a basis to help enumerate risk. And how do you do that if I'm telling you it's going to cost $1,000? All right, that feels like almost an insignificant risk. If I'm telling you it's 4% of your revenue, that's a pretty significant risk, and you can have that sort of conversation. So yeah, and this is actually from Trustee. They have some really interesting documentation. I don't know if you've ever gone to them. There's a few companies like that out there, but I pulled that from them. They have a GDPR readiness component and stuff like that. That's interesting if you want more details on this. So we talked briefly about, I was going to talk about the right to be forgotten and access and why do I have a data map and all of these things. So you actually have a right to have your information deleted. And that's a really interesting concept because, again, if you don't understand, and most of us did not raise our hands in this room, where your data is, how are you meeting the obligation to delete your personal data if you don't understand where it is, right? And they, like I said, this is a right. And you, with the right to be forgotten, I don't know if you guys have been following the cases with Google. You have teams of people, actual people, evaluating these requests.
Thousands,
Yeah.
not in tens, thousands.
They are getting so many of these requests from people, and their search is a little bit different, but it doesn't mean that our obligations regarding deletion don't exist. And there are exemptions and things like that, but generally we have to have an understanding of where the data is to be able to delete it if we have personal data. And again, the other kind of interesting aspect, which I find really intriguing, is the right to data portability. And so that, when you think about Europeans feeling like it's a human right, they own it, it's theirs. It's the right to take their data somewhere else. So I gather my data and I put a question out to your company and say, send me all my personal data. You have an obligation to send it in a structured, commonly used, machine-readable format. And then I'm allowed to take it to someone else. I can take it to your competitor. So it's not just, in the positive sense for our organizations, you would hope you'd get to ingest lots of data from other people. You have to be able to ingest. You have to be able to provide and also receive that information. And so it's something that I don't think most companies are really readily able to do at this current point.
Right, and a lot of different industries don't have standard formats for the data, standard data models to support that. So you have to find ways to do that roughly. And the other aspect of it, when we think of it as security people and tend to be a little twisted this way. Once you have that right to request that, what's to stop me from requesting her data, right? And how is the company going to validate that it's her requesting it and not me requesting it?
So, I mean, I think you have to look at it whether or not that derived data is still personal to them. And that's where that definition of, without seeing it and understanding it, that's really where the distinction is. Because it's not like all data that has ever existed. It's your personal data that you have a right to. And for those of you who haven't, we always talk about the example we give is Facebook actually has a really excellent model to pull down. And it's really intriguing if you've been on Facebook for a while to pull down all the data you have on yourself. I don't think I would be able to give it to someone else, but they do have a way of capturing it. And at least you have a right to access your data. They've provided that ability to access it. They don't know if they've yet solved for portability. And then one more slide to kind of talk through. I know we don't have a lot of time, but breach response is really critical. How many of you guys sit on your breach response team? Okay, so a few of you. You're going to have a data privacy person on there. It might be your legal counsel, but you work hand in hand together. And what they have done is previously, some countries did, but not all, had mandatory breach requirements. They've actually set an outline for what this looks like and what their expectations are for their regulators, which we're calling supervisory authority here. But they have an expectation that you're going to notify within 72 hours. Now you can expand that if you need to, but you have to be able to justify that delay. And imagine that, like within 72 hours of a breach, what do you know? Are you prepared? And so it's a really important thing. And also they add the component of notifying impacted individuals. And there are some kind of exemptions if you've taken certain security steps to make that data not as useful, like encryption. You can find out if there's no harm to the individual. There are components of it. But understanding what's going on and adding this breach requirement, which we're all in the United States, you're used to this expectation in a lot of states, but they're now rolling this out across Europe.
Yeah, and think about that in context with Yahoo, in that recent event where they effectively, it's years, I think it's, depending on what you read, it's 2, 3, 4 years between the time they knew about it and the time they disclosed and reported that to the public. So that's a huge change.
We have some takeaways for you. The first is not on here, but I'm going to say, if you haven't met your privacy person, go meet your privacy person.
That's got to be step 0.
Yeah, I mean, we're pretty awesome. I know I seem really scary, but we're pretty awesome, I promise. I have a cartoon up here from Daniel Solov. He's a professor out of, I believe, GW. He's got some great resources out there to train and teach and know more about data privacy. But privacy and security by design. This is your opportunity. This is your stance to get out there. Develop your data maps. You guys have 1.5 years to work towards these things. Do it now. Don't be dealing with this next December with your hair on fire that you've got 5 months to figure this out. Yeah. Encrypt where possible. That helps. That helps emphasize that you've taken and made the data not valued if it's taken. So here's just some tips, and I want to thank you guys, and I hope that you do reach out to your data privacy people.
Your questions, and we'll be up here for any additional questions after.